रेडियो जिंदगी 92.3 FM HD2 पे वेलकम लिसनर्स, मैं हूं आपके साथ में ईरा. वेलकम टू द शाह Pirali Law Show, brought to you by the Shah Pirali Law Group. We are once again joined by attorney Shah Pirali on air with us. Attorney Shah Pirali is the founder, president and managing attorney of the Shah Pirali Law Group, which is headquartered right here in Newark, California. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action, and social services, and he has a strong interest in and knowledge of the political and the legal system here in the US. He formed his law group to work on the causes that he feels most ardently about. The law group focuses on immigration law with an emphasis on employment based immigration. He helps his clients all over the US. So, whether you're in San Francisco or Washington, D.C., or East Coast or West Coast or anywhere, you can be helped because they do have offices in Newark here in California, San Francisco here in California, and also Washington, D.C. on the East Coast. Listeners, if you'd like to get in touch with him, you can call us right now during the show on the studio number 510-657-1170. That's 657-1170. You can also get in touch with him after the show on his direct number 510-742-5887. Well, you can also call on that number right now as we speak. Since it's an office number, you can call on that number and make an appointment, 510-742-5887, and get all the information about attorney Shah Pirali and his team and the practice on the website piralilaw.com. That's PEERALLYLAW.com. So without any further delay, attorney Shah, good morning and welcome to the show.
Good morning, Ira. Good morning, and thank you for always be with your warm welcome, and really appreciate all your help and your good work. So
Thank you
so much. No, I never have a chance to. Well, I do, but unfortunately, sometimes I forget. But you're really very helpful, and I'm very, very grateful to you on that.
Thank you.
You're welcome. And just to let you know, last week I didn't do the show. It was Eid, so Eid Mubarak, a little bit late. And also, I wanted to let people know that now we are 92.3. For those who are going to be listening to the show on YouTube, because I upload them on the podcast on YouTube on Shah Pirali Law. So please tune in. 92.3 HD2, right?
FM, yes. 92.3 FM, HD2. HD2 is the most important part.
Okay, so just to let you know, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. I think we already have one caller, right? So let me take the call
Then we can... Yes, we do. We have a caller who's holding on to the line. So let's take this call and see what they'd like to ask you.
Thank you.
Hello, you're on air with attorney Shah Pirali.
Oh, hello. Yeah. Hi, Ms. Pirali.
Hi, how are you, sir? Good. I'm listening to you. Thank you for waiting.
So my parents, they are in India right now, and they applied for green card through consular processing, and they're waiting for like a year and a half for interview to happen, and that doesn't seem to move at all. I was thinking of two steps, right? One is bringing them over here to using their tourist visa. They have the 10-year multiple entry. And second step, to convert consular processing to US. Would you recommend that overall? Is that any opinion on that path?
Okay, that's a very, very frequent question. In fact, a lot of people asking me the same thing, but thank you for asking it. So what happens is that the way it works, number one, they can come here probably on the tourist visa, but I don't know if they're accepting tourist visa, if the ban is. But for those who already have it, they probably will allow it. But there's a glitch there. There's a problem there because once you have a case pending like that with a tourist visa at the airport, they might. At the border, in the US, they have a right to deny them entry, and that's the risk that you have. If they return them, they can put what we call a summary proceedings on them, summary deportation, and then for 5 years they won't be able to come back. Now, let's say they get in once they get in, if you go ahead and file for the adjustment of status, which is allowed, there is another problem under INA 214B. They can basically tell you the case is you kind of trick the system to enter, and they can give you a hard time. Now, having said that, from my experience, most people don't get in trouble, but if in case they come, it is not a good idea to file right away. And as a lawyer, I cannot recommend you to actually do that. Although it is possible, it has a lot of issues of fraud, etc., involved. If in case they want to put that on them, it will be a nightmare for them.
I see. Okay. Yeah, that was my main question. And
Yeah.
even if we don't apply right away, should we like wait? I keep hearing you should wait like 50 days, 90 days.
90 days. Yeah. Okay, I'll tell you, this is not really a rule. This is an accepted thing. It was 60 days before. Now it has become 90 days. The first 90 days, there's a presumption of fraud if in case you apply for an adjustment of status as soon as you enter. But unfortunately, the way the law works, if you already made up your mind before you enter, then you are in violation of the INA 214B, and plus also they might charge you of fraud and misrepresentation. And but if you make up your mind after you enter, let's say your parents were already here, then they made up their mind, then the issue is not there. Now, a lot of people ask me, how do they know? Well, the truth is the truth, right? So if you find out, you're going to be in trouble. So to be on the safe side, I don't recommend you trying that. However, unfortunately, with the COVID, a lot of people are actually looking into it. So give me a call at the office. We can discuss more in private. 510-742-5887. We can assess what are the options for you. Okay? Okay.
Okay. Yeah. Thank you very much.
Good luck to you. Thank you so much. And any
I'd like to remind all the listeners that if you also have any questions, you can call us right away. We have Attorney Shah on air with us till 11 a.m. So call us right away on 510-657-1170. That's 510-657-1170. That's the studio number. But if you'd like to make an appointment with the office for a private, more detailed discussion to discuss your case in its entirety, you can call the office number to make an appointment 510-742-5887 or log on to the website peerallylaw.com. That's PEERALLYLAW.com. Yes, Tanisha, let's get started for today.
Yes, I didn't really kind of catch up on the news, but so I'm going to talk. One thing is, for those people who come on a visitor visa or who are changing to a student visa, it used to be that there was a rule that was passed in 2017 by Trump requesting that you have a bridge set up. What we call a bridge is that you have to file an extension B1, B2, and then file your student visa or file it sometimes concurrently, because without that, they were using the rule of the 30 days rule of approval to start school, and they were denying cases for those people who have not filed this B1, B2 underlying when they file for a change of status to F1. But I think they have gotten rid of this rule, which means now if you file for a student visa and it will be pending probably for 1 year, you don't have to file anything else while you're filing this. So this is one good news, because it's not people's fault that the system is delaying. So requesting the 30 days of before starting school that you are maintaining some kind of other status is not really sensical, honestly, but they were asking it, and a lot of people kind of had to be either an H4, etc. But now this issue is not there. So as long as your status is good, you can change the status to F1. And if you need help, give us a call, 510-742-5887. I just wanted to mention that. Today, I'm going to talk a little bit, Ira, about Any callers? Hello?
No, I'll let you know. I will let you know.
Okay. So I kind of heard that somewhat. So I just wanted to talk a little bit about family petitions since we started with the family petition question. A lot of people are calling me for the same thing now. Their parents are here and they are not going back, and because of the situation in India, they are worried. Many of those people were having like what we call multiple entry visa under B1, B2, which is a visitor and business leisure visa. And then they were traveling with that without any problem. Even if their children are US citizens, they were not very interested in getting a green card, so they will use their visitor visa. But with all the situations happening in India, a lot of people are feeling more comfortable to have their parents by their side. So if in case your mom or your dad is with you here and you don't want them to go, you can and you're a US citizen, or your sister or sibling is brother is a US citizen, you can file for the green card straight in the US. And the previous caller mentioned the 90 days rule. If they just entered, I don't recommend filing right away. Wait the 90 days. But if you're planning to kind of try to bring them on a visitor visa to file it, that can entail what we call a situation of fraud and misrepresentation. So be very careful. Run it by a lawyer before you make your decision. And you can give me a call, 510-742-5887. Darshi in the office will gladly schedule a consultation for you. Just to let people know that many times when I call them, they just call back on the number I call them on, but usually I don't check those numbers. So the main number is 510-742-5887. That's the main number. If you want to schedule something, please feel free to reach out on this number. So going back to the parents' petitions, like I said, if now your father or your mother are with you in the US, you can go ahead and file for the adjustment of status, I-130 petition, adjustment of status, I-765 work permit, and I-131 re-entry permit. The reason a lot of people ask me that, hey, we're filing a parents petition, why do we have to apply for the EAD, the work permit, and the advanced parole? But I'll tell you, there are two good reasons for that. Number one, the case will take usually 8 months to 1 year to process. If you file for the work permit, once you get the card, you should be able to easily go and get what we call a social security number for your parents, and ultimately an ID or some kind of driver's license. So it is important to file that I-765 form, and missing it, you're just missing on something good. Plus, there's no extra fees when you're filing it with the adjustment of status. So be good with that, because if you make mistakes how things work, then it will get more confusing in the future. So what happens is that when you file that 765, I-131 is an advanced parole. Many times when I speak to elderly people coming here in the US, after some time they get bored and they want to go back. If you don't have an I-131, which is advanced parole approved before you leave, the entire case is deemed abandoned, which means the green card will stop being processed. You will have to either process it to the National Visa Center, the US consulate, or some other or bring them back, which is all the risks that I mentioned earlier with the caller. So the best is not to travel until you get either the I-131 approved, advanced parole, or you get the green card approved. So make sure that you understand that, because it has a lot of implications once you just try to leave. And like I said, people, elderly parents, they tend to just want to go travel, visit, and check on their stuff. So just let them know, without the advanced parole, which is the form I-131, do not make any kind of move outside the US. Now, the other thing that a lot of people don't know about when it comes to parents' petition is, and also spouses of U.S. Citizen. Let's say, for example, your parents came on in January 2019, right? They stayed here till July, June. They hadn't, when they entered, they gave them a 994, which goes to June. Let's say you file an extension for them and you got that extension approved. Now, with the COVID situation, a lot of people file another extension, and some are getting approved, some are getting denied. And let's say in this scenario, you're getting a denial. Now, they're already going to be out of status by the time you get the answer. Now, what can you do next? If you're a U.S. citizen, and that only applies to U.S. citizens, you can actually kind of go ahead, still file for their green card. I repeat that. Even if someone is out of status, and provided they entered legally on certain visas, they should be able to adjust status inside the country. So it is important also to understand how the system works, and don't get confused between the Department of Homeland Security, the State Department, etc. Because when you file the case, it's important that you do everything properly. So another thing that I wanted to mention when it comes to family petitions is that, like I said, if you entered on a valid visa and you overstay, you can still file those cases. And a lot of people ask me, they have U.S. U.S. Citizen children, can they file for their parents? The answer is yes, provided that they are turning 21. So only when they turn 21 they can petition for you. So you cannot use a petition from someone who's under 21. So that's the way the system works. So if you need help now to apply any of those, feel free to reach out. 510-742-5887, 510-742-5887. Any questions, Sarah?
No, it's a great topic that you're talking about today, Attorney Shah. A lot of people do wonder about parents, visiting over here, and also, their permanent residents. So great topic. Listeners, if you also have any questions about that, you can call us. In fact, not just about that, any question about immigration, any question about your immigration case, which is pending or which is in process or about to be started, you can call us right away on 510-657-1170. Right now, when there are, the H1s are being processed and there are so many RFEs which people are receiving. So if you have any questions or if you need second opinion, get in touch with Attorney Shah and his team. The number to call right now is 510-657-1170. That's 510-657-1170. You can also get in touch with Attorney Shah's office and his team through the office number 510-742-5887. That's 510-742-5887, and the website is piralilaw.com. We have a question. We have a caller. Let's see what they'd like to ask you. Hello, you're on air with Attorney Shah.
Hi, Ira. I'm calling from New Jersey.
Hi.
Please go ahead.
Hi. My wife has filed for 85 in October, and as well as she filed myself and my son. My son is 20 years old. He is studying in India. So while her application, she has filed 824, I-824 for my son. So most probably her PD will be current in next month. So my question is, his age will be locked once my wife's PD will be current?
Yeah, and the Child Status Protection Act, it should be, but the problem is that the fact that your son is outside the country, it makes things a little complicated. If he was here, you had filed the adjustment of status, it would have locked it. But unfortunately, because of the timing, they're processing stuff. If the case doesn't process before he turns 21, you might have an issue. So it should lock it because the date became current, but until they start processing it at the National Visa Center, they might not lock it. So one of the things you might want to do is to see if your son can come back on his H4, because you probably have an H4, and once or he an advance parole, and once he gets here, then you lock everything. At least you can get what we call an advance parole, and then after that he can leave. The dates will be locked. So that is probably the best solution. The other solution with the National Visa Center is a little bit too complicated to really kind of state that the Child Status Protection Act.
Okay, I got it. But problem is that once he has the H4 visa valid till 2023, but he is studying there in India due to visa problem, all those. So he doesn't want to go F1 and all those.
Okay. Yeah, definitely.
So he can come, but problem is that he has to wait for biometric also.
Yeah, exactly. Even he comes here, if he comes here, if you file, he will have to probably stay here for the next 6 to 8 months to at least get things clear. Then he can travel back. But the problem, to answer your original question, unfortunately, the dates might not be locked until they have something more concrete. So the best is to bring him back and follow the paperwork. Otherwise, you might just want to go ahead and make sure that hopefully, let's cross our fingers, that they start processing the case at the National Visa Center, and then you can claim the Child Status Protection Act. Okay?
Oh, okay. Thank you, sir. Have a good day.
You too. Thank you so much for calling us. And anything else, Ira?
No, that was the call. I think he hung up now. Yes, thank you. Please continue with the previous one.
Yes. So talking about family petition now, marriage petitions also allows to a U.S. citizen also allow a lot of differences. So same rule, kind of. Let's say you enter the United States. Let's say 1 year later you decide to get married, and you entered legally, and you decide and you stayed unlawfully, but at a later stage you decide to marry a U.S. citizen. You should be able to bring things back on track. So the marriage to a U.S. citizen kind of put you in what we call an immediate relative. Now, as long as you entered legally, and even if your I-94 is expired, you're married to a U.S. citizen, you should be fine, and you can file adjustment of status. However, if your spouse is not a U.S. citizen, then things will get a little bit more complicated. So it is important then, in this case, to double check. And then if, let's say, your spouse is a green card holder, right? And then as a green card holder, you cannot file an adjustment of status unless you are in status. So for example, let's say you're an H4 or F1. These are status. And status is basically what you really kind of need to stay in the US. So it is important to make sure that things are being done properly when you're filing the cases. Now, if someone didn't enter legally, right? Let's say someone crossed the border or something, marriage to a U.S. citizen will not really help. So make sure that if you're not a U.S. citizen, then you maintain status before you file those adjustment of status. So,
okay.
Yeah, go ahead, Ara.
No, I was just agreeing. I just said yes.
Okay. I heard you say. I thought you wanted to ask something.
No, don't worry.
But bottom line now, if you want to be to file for adjustment of status inside the US, make sure you're compliant with all the rules, and talk to a lawyer, and we can help you if you need help. 510-742-5887. 510-742-5887. Now, another thing that a lot of people don't know about, let's say you entered the United States without any kind of papers, right? You cross the border or something, and then you marry a US citizen, you're not going to get a green card to that unless you are an abused spouse. Then in this case you don't have this issue, and you can ultimately get your green card. So all those things are very important, because a lot of people just dump stuff and they don't really know what they're doing, and it ends up by creating more problems for them and for the entire family, because they make mistakes on many things. And then while VAWA, which is the Violence Against Women Act, you can file it even if you entered illegally. You can get your adjustment of status. However, if you entered on a valid visa, and then you want to try to get the marriage petition going, and something is wrong, you probably will not be able to do what we call you will not be able to get the green card because you didn't enter legally. So it is important to talk to a lawyer before you file anything. And again, the number to our office, 510-742-5887. Any callers are?
We were getting a call that got dropped, so I'd like to remind the listener that if you're still interested in asking your question, you can call us right back on the same number. And also, for the benefit of new listeners who are probably just tuning in, we are in conversation with Attorney Shapir Ali from the Shapir Ali Law Group, and we talk about immigration here. So if your question is about immigration, it doesn't even have to be related to today's topic, to what we are talking about today. It's okay. Your question, if it's about immigration, you can call us right away and speak to Attorney Shah. 510-657-1170. That's 510-657-1170. And you can get in touch with the Attorney Shah and his team on his office number as well, 510-742-5887. Get more information about Attorney Shah and his practice on the website peerallylaw.com. That's PEERALLYLAW.com. So you said, Attorney Shah, if somebody crosses the border illegally without papers and then they marry a citizen here, it does not help their case. What about people who probably came, legally, maybe on a B2 and then never went back?
Yes, that's a big difference. That's a very good question you just asked. If someone entered an illegal visa, right, for example, a visitor visa, B1, B2, or some other visas like H4, H1, and then they overstayed, let's say after that they fall out of status, but they didn't go
Attorney
back.
Shah, sorry to interrupt you. We have a caller who would like to ask you a question. So let's speak to him and then we can continue.
Okay, go ahead.
Hi, you're on air with Attorney Shapir Ali.
Hello. Hey, Sean. I have a question about this adjustment of status. So last year in October, my adjustment of status was filed, and so now, at that point of time, I wasn't married, so I couldn't add my spouse. So now, again, my priority date is current. So is it better to add my spouse right now, or if anything, until my adjustment of status gets approved, can I add her after that as well?
It's better to add now, because you will have, she's not in the US, right? She's outside?
No, she is in the US.
Okay, so I would recommend getting her the adjustment of status file right away, because it's a lot easier than waiting. Because if you wait, then if you get the green card is issued, then you will have to file as a green card holder, which will be a little bit more tricky, because then it takes a little bit more time. But if you file the adjustment of status now, she will get the green card probably with you. So go ahead and file it now.
Okay, I see. So I see that right now, at that point of time, many who have then submitted the medical, they may get RFE based on the missing medical on the file, right? So if I get RFE based on this medical issue at that point of time, also I can add her.
You can add her anytime before the green card is issued, but I would recommend doing it now.
Okay.
Why you will want to wait for the RFE because the adjustment of status is a separate application. It won't affect your case. So all you have to do is to file it. And if you need help, let me know. We can help you on that. Okay?
Okay, I see. All right, sure.
Okay. Good luck to you. And wish you all the best. And congrats for your marriage.
All right, yeah, thank you.
You're welcome. So yeah, that's an interesting question too.
Yes, indeed.
Yes. Do you have any other caller, or should I continue?
No, you please continue.
Okay, so let me. Yeah, you were asking the question. Let's say someone entered on a visitor visa, and then they go ahead and they overstay, and then they get married to a U.S. citizen, or they have a child who turning 21 is a U.S. citizen who wants to file for them. Even after years, you can still do adjustment of status. I repeat that. If you entered legally and on certain visas, not all the visas, like for example, coming on C1, etc., you might not be able to do that. So it is important that you, in those situations, you contact an attorney and file it properly so that you don't get into trouble if you file the wrong paperwork. Now, there is an exception also for people who entered what we used to call EWI, entry without inspection. It's called the Life Act. The Life Act, what it basically is that if something was filed for you, like a labor certification or parent or some kind of other petition, I-130 was filed for you or your family sometimes, you might be eligible for what we call INA 245I, which means even if you entered EWI without inspection, you will be able to file adjustment of status. These are petitions that are filed before 2001, April, or 1998. So it is important if you entered, because I'm getting few calls of people right now for adjustment of status where they have this situation. So that's why I was mentioning it. So you can still, as long as you entered legally, you overstayed, you can do adjustment of status. But if you entered without inspection, which means basically you entered by crossing the border illegally, then things are very different. But under VAWA, if you're being abused, this rule doesn't apply. Okay, I repeat that. Let's say, for example, you are married to you entered unlawfully, and you married a U.S. citizen, and then that person abused you, either emotionally, physically, sexually, or whatever way, or a combination of all, you are eligible to file the adjustment of status without having to leave the country. So that is one exception. Now, the other thing that a lot of people also look at is that what they do what we call the 601 waiver. There are two kinds of 601. There's one 601 regular, but now in 2012 or 13, I forgot, Obama introduced something called a 601A waiver. What was happening is that people who were overstaying like that and who entered unlawfully, they were eligible to file what we call, they were not eligible to file adjustment of status, but if they leave the country, they file for a 601 waiver. If it gets approved, then they can come back. The case gets processed outside, because when you overstay, another rule kicks in. It's called the 3-year or 10-year bar. So it blocks you to come back. But with that 601 waiver, people are able to come back. A 601 waiver is basically a forgiveness, and it requires extreme hardship. That's a part which is the most difficult. And it has to be the hardship is not on you. It has to be on the U.S. citizen spouse, or sometimes it doesn't really work with children, but sometimes with parents and stuff like that. If they're U.S. citizen and they need your help, then you can claim that hardship. Now, Obama, what he did, he introduced a rule where instead of people having to go back and apply for it, and if it gets denied, they don't know what to do, he allows people to apply for the 601A waiver. If it gets approved, then you go outside and you process your case to the U.S. Embassy, and you come back with your green card. So family petition is a very tricky, it's not tricky, but if you don't know really how to file the case, because there's a lot of paperwork, better get the help of an attorney. And again, we can help you. We do a lot of family petitions. You can give us a call and we'll be glad to help you. Any callers, Ira?
Yes, we do have a caller. Let's take this call. Hello, you're on air with Attorney Shapir Ali.
Yeah, I have a question for Mr. Shah.
Please go
Yes,
ahead.
sir.
Yeah, so I was curious to know about the EB3 prediction for this year. What is your take, Mr. Shah?
That's a good one. You are going to ask me for Christopher, but I'll go ahead and shoot a little bit from what I know. I think it will move to 2016. I think I said that before, to January max. And then that will happen probably by October visa bulletin. That means in September we'll know that. That's my feeling is that that's the max it will go, January 2016, or a little bit further maybe, but not more than that, because now after that what happens is I think it will stay like that until probably April next year. Then you're going to see a huge retrogression, because what will happen is that there will be a lot of people consuming those visas, and suddenly you're going to see retrogression start popping up. Now, unless I'm completely wrong, or COVID has kind of skewed the whole system, we might not see a retrogression, which everybody's praying. But I don't think it will go above 2016, January probably, maybe March. And that's my feeling. Now, the scenario which is more realistic is up to 2015, and that's where it's going to stop. But many people are hoping that January 2016 will be the dead date.
Okay, and I have a follow-up question that I'm changing my job now. So my question is that should I ask them to process my I-140 on the basis of EB2 or EB3? Right now, I'm EB2.
Okay, that's an interesting question. What I recommend people to do is to do the labor certification under EB2. So prepare everything under EB2. And then when you reach the I-140 level, depending how things are behaving, you can always file under EB2 or EB3. But if you process it under EB3, and then you reach the I-140 level after the labor certification, which is kind of 1 year down the road, 1 year, 1.5 years, what will happen is that you won't be able to go on EB2. And my feeling is that EB2 is moving slowly, but it's moving surely. So EB2 might overtake things after the retrogression kicks in for EB3. So in this case, I would recommend do your case under EB2, see how things are progressing. And then once you reach the I-140 level, if EB3 is still doing better in 1 year down the road, you just go ahead, you file under EB3. But if you do the case under EB3, you won't be able to do that under EB2. That's it. Okay?
Yeah, and my follow-up question on that is it recommended to change a job during this time when the things are moving faster than before?
Changing job depends how you're changing. Was an adjustment of status filed for you?
No.
Okay. Then, yeah, that's true. If you change job now, you're going to get an answer in 1 year. And if in case things get moving in between, what is your priority date, by the way?
January 2018.
Okay. I don't think it will reach there, but again, I might be wrong. So I think if you're getting a better job, you should go for it. And but again, like I said, I cannot really predict this exactly, but I don't think it will reach 2018. Okay.
Okay. Thank you, sir. Thank you very much, Mr. Shah.
Good luck to you. Thank you very much for the question. And this is something very pertinent right now with all the downgrade, upgrade, or whatever people are doing.
Absolutely.
It is important to know where we stand. But again, sometimes people ask me question, what will happen next? It's very hard to predict. The visa bulletin is a very wild animal. Well, I like wild animals, so I should not say that.
Yes.
So it
Please don't
is.
bring animals into this. Poor poor
Yeah,
thing.
yeah, I will be insulting them, especially I love animals. So no, it's let's say a wild card, then we'll say that. It's going to be a very kind of, we're going to see the trend. Next month we're going to start seeing the trend, and then September we will know really how things are moving, because October 1st is the new fiscal year, and things are going to, every year when you reach the October 1st, we see a huge jump or huge retrogression. Usually it's a huge jump. So let's hope that will be the case. But I don't have much hope that it will go beyond that 2016. That's my feeling. But again, I might be completely wrong. I'm not a psychic. I'm just making an intelligent guess here. So your guess is as good as mine. So don't hold me to that. Anything I'm telling you is just an opinion. You should not act or refrain to act solely on the information provided. And I always say that disclaimer, but that's truth, especially for when it comes to those visibility and predictions. Any other caller?
No, not at the moment, but I would like to remind everybody that we have approximately 13 more minutes to go, 12 or 13 minutes. So if you have a question, right now is the time. Call us right away on 510-657-1170. That's 510-657-1170. Or get in touch with Attorney Shapir Ali's office and his team for a more private discussion about your case. 510-742-5887. That's 510-742-5887. And the website for more information about the practice is peerallylaw.com. That's PEERALLYLAW.com.
Yes, indeed, Ira. So, we were talking about family petitions and also adjustment of status. Since people have brought us really into the adjustment of status, for those people who filed in October now, a lot of people seeing their dates current want to shift their job, right? Under AC 21, I think Section 104C, you are eligible to move from one company to another, provided you meet the two requirements. Number one, that 180 days has passed. And number two, you're moving to a same or similar position. What has to be done is that when you're doing that, you're basically moving the green card completely from one company to another under AC 21 rules. And you need to do a supplement J and put a letter of employment, and of course other stuff that might be required later. So the question is, when do you file that? I recommend filing it as soon as possible, especially dates are moving really fast. So you want this to be there before there's an interview or something like that. So don't delay on those stuff. So it's very important. So I wanted to mention that. So I think we have 10 minutes. Let me talk a little bit about, since we were also talking about VAWA, talk a little bit about our petition for H4 visa holders. We're going to try kind of keep the momentum going on this. I know a lot of people have so many issues with the COVID, jobs, etc. But we need to take some time to think about those people who are suffering once they get they came on H4 visas and suddenly they find themselves without a visa because of a divorce, which pretty much oftentimes is almost like an abandonment by the H1B holder. So we are trying to change that law, because a lot of the abused people on the H4, or not abused, but at least things are tough for them. The marriage didn't work out. Now suddenly they are dependent, right? And they are in the US. They've been living here for years, and suddenly they see themselves out of a status because their spouse is divorcing them, or they're divorcing their spouse, whichever way, and then they don't have anything to hold on to. If they have been abused and they have domestic violence, the U visa can help. And ultimately, there is an EAD that they provide in abuse cases, but they don't provide a status, which is kind of a little bit counterintuitive. So they're giving you a work permit without giving you the right to stay, which a lot of people always kind of saying, hey, how does it work? So many people have opted to go for a student visa. And just to let you know now, I was mentioning that earlier, you don't have to file the B1, B2 while you're filing the student visa now. So you can just file straight the student visa to stay. But at the same time, student visas cost a lot of money. And most people who just came out of a divorce are let's kind of admit it, broke, right? So how do they deal with that? And that's what we're trying to fight and get some kind of law amended for the H4 visa holders who are basically kind of losing their status. We need to give them at least a grace period or some kind of temporary status. Once the divorce is decreed, they can still stay in the country for them and for their children. And that's why we started this petition online. And it's on unchange.org. If you type Sharp Rally, you will see my petitions there. Please sign it and pass it to your friends. We need some good signatures so that we can kind of bring this up to the uh, to the lawmakers. Although I know they're not going to do much, but I'm hoping Biden will pass some kind of protection under executive order. So it is important that you sign this and support the cause. Although it is you are not an H4, you're not in that situation. It is important to support people who are in that situation because you never know, you might get there. So always be helpful to others, and have getting your signature on this will be very helpful. Possibly to change the law. Please sign the petition. It's on change.org, and I think Ira, you have it also on your wall or something.
Yes, I do. That petition is on my RJ page. So, listeners, if you log on to Facebook and if you go look me up, RJ Ira, that's RJIRA, you will be able to find that petition right on top. So, you can sign it, spread it, share it with your friends and family and anybody. Because, like we always say, more people than we know suffer with this problem, suffer because of this, amazing rules and laws. So, let's help these people who are suffering because of this. Sign the petition and spread the word as much as you can. If nothing, then just even awareness helps a lot. So do it.
Thank you so much. Yeah, it is very important because don't think that, okay, when you help others, it's always a great satisfaction. Plus, you're doing the right thing by signing this. It will protect a lot of people who are unfortunately being victims of a system which has not been updated. It's more like putting the spouse dependent on the other spouse, and that means if something goes wrong in their relationship, the one of them is going to suffer. Especially when you have a long divorce going on, you have to fight in court with other stress that you don't have any kind of status. It makes things a little bit more stressful, and we want to hopefully kind of avoid such kind of stress. So I recommend that please sign it, and change.org is help the H4 visa holders. And also please share it with your friends, etc. So any other
we
yes,
have a caller who would like to speak to you. Let's take this call.
Sure.
Hello, you're on air with Attorney Shapir Ali.
Hey, I have one question. Actually, my priority date is October 2012, and right now, it is current for final action date. But I don't see any update on my EB3 downgrade or any EAD or anything. I already gave my biometrics. So I wanted to know, usually how long does it take, or how does this process follow through?
Okay, very good question too. First of all, until the EB3 is approved, nothing is going to happen on your side, except basically they might ask for medical and all the stuff, but they won't process the green card itself, which is the I-485. What I would recommend is talk to the lawyer who filed the case for you and see if they can upgrade it to premium on the I-140. If you're eligible for it, see if they can upgrade it. That will be very helpful. That's number one. Number two, the other issue we're facing is that suddenly with all the dates becoming current, they are expecting almost up, I think 250,000 or 260,000 applications. And the government said, I think I saw it somewhere, they said they won't be able to process that many. So don't think probably you will get anything, even if the I-140 is approved right now. So you have to wait and see. So bottom line, it is important that you pretty much kind of keep a record what is going on, and check with your attorney if you can upgrade to premium on the I-140. Okay.
Yeah. Actually, I talked with my attorney and they mentioned that there are risks because they have seen many rejection in I-140 premium. So they are not recommending on doing that. And also they are suggesting that right now you cannot file the service request or something because there is some 2 years of backlog ongoing that the USCIS is processing with 2018 date for the service request. So you cannot request that as well.
Yeah, that's another way to see it, but it is. I don't see any reason that because many people are doing it and have no problem. So it's a case by case basis. But in your case, since the dates are becoming current, it might be a good idea to go premium.
Okay, I see. Then, like, once the adjustment of status is approved, how long it takes to get the green card?
Well, this is the thing. If it is approved, your green card will come. It's already the green card is probably going to be issued within few weeks. But the biggest problem they're having is they don't have enough people to process those cases. So even people who are the dates are current, you might not see any kind of green card coming for the next 6 to 8 months.
No, okay.
Okay.
Okay, I see. All right.
Good luck to you. Thank you so much. And I think, Ira, we don't have much time left, right?
We have 2.5 minutes.
Okay, so let's kind of wrap up now, close. We got a lot of callers today. Thank you so much to all the listeners. And for those who are able to reach us on the show, feel free to call our office, 510-742-5887. We can schedule a consultation. Usually it's a paid consultation, but sometimes I check on those. So please give us a call, 510-742-5887. And just to kind of wrap up, I think we have another 1 minute now. I just wanted to mention that I was talking a little bit about the situation of family petitions,
Yes.
and then people who are out of status, and then ultimately we move to H4. So for those people who are filing whose parents are here in the US and they are US citizens, it's better than to file a straight green card rather than just go ahead and try to extend their visitor visa, which is a big headache. So if you need help on doing an adjustment of status for your parents or for any kind of case or any type of case, please feel free to reach out, 510-742-5887. And again, you can check our website. It's piralilaw.com. I'm forgetting my own name. PEERALLYLAW.com. And also, again, 510-742-5887. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. Thank you very much. We'll be back next week, same time. Thank you, Ira. Take care. Bye-bye.